Hello and welcome to this lesson on data rights, understanding and negotiating data rights in government contracts. In today's lesson, we're going to cover an intro to data rights. What are they? How do you use them? Types of data and associated rights, understanding rights categories, acquiring and allocating data rights, commercial software and data rights, managing subcontracts, and emerging trends. So understanding data rights, when we think about data rights, we have to understand that when we're building technology or buying technology, somebody owns it. And for a long time in the government, we really didn't pay that much attention to it. And we really found ourselves in situations where the government, the taxpayers, had paid for software to be built, but we gave away the rights to it. And contractors owned it, which ultimately locked us into that vendor in order to continue using the solution that we paid for to build. In recent years, we've gotten much more savvy about it, but it's also gotten a lot more complex. So we're going to unpack a little bit of that today. Uh, there are FAR provisions that provide a basis for negotiations, and that's a good place to start. But understand that data rights, like any contract term and condition, is ultimately a bilateral agreement. So it's where do we end up meeting the vendor at a place where we can execute a contract and agree on how we have the rights set up. The first place to look is technical and data and software. So when we think about technical data, we're thinking of recorded information. This is the information that's going into the software or coming out of the software. It's what's produced. It's kind of tangible information, and understanding who owns that information is one piece of the puzzle. The other part is the software. Software data rights refers to the code or the algorithms that are powering the software. And that's where things can get a little bit more complicated. Commercial versus non-commercial. So commercial companies will generally have established rights that they introduce anytime they sell. Think of Microsoft terms and conditions, end user license agreements, and non-commercial data, which is software that we've paid for as the government to build and create. Of course, publicly available data is just as it sounds. It's data that's accessible generally to anybody. And restricted data is information or code that is produced under a controlled agreement. When we think about data rights as far as government terms go, there's generally three main categories: unlimited rights, government purpose rights, and restricted rights. Unlimited rights are unlimited as they sound. So they're available. The information, the code, or the software is available to anyone in the federal government, but the federal government can also make it available to anyone outside. That means competitors can have access to the same code that was written under a contract and not only use that code to sell it back to the government, but to sell it anywhere else in the private sector as well. This is generally the starting place for contracts that the government is paying for custom software development. The belief is the taxpayers paid for it, so it should belong to all the taxpayers. Government purpose rights is a bit of a middle ground. So government purpose rights, again, commonly associated when the government pays for the development of software, means anyone in the government can use it. So the government can give it to different agencies, different parts of the agency. They don't have to pay for that code to be built again by the same vendor or any other vendor. The government can give it to industry, but only for the purposes to be used within the government. They can't turn it over and then industry can sell it to the private sector or resell it to the government. Limited and restricted rights typically is associated when the vendor has invested their own money, such as internal research and development dollars, venture capital dollars. They've paid to write the code or the algorithms that have created the software, but it might not yet be commercial or covered by commercial rights. Restricted rights mean they're negotiated, especially negotiated rights. And generally it means the government can't reuse it without express permission from the company that produced it. Specifically, negotiated rights is kind of a level down into that same category where it's worked out between both parties how and whom can use it. When we're acquiring and allocating data rights, we need to determine the needs and negotiating it. Sometimes the government doesn't care, they don't need it. Where we generally will always want to protect government rights is the data. So if we are giving information into a tool that the vendor brought or built, then the government wants to own that. They should have at least government purpose rights on any information they're providing to the vendor, and typically the information that's the outcome of the software. So if the software manipulated that information to produce a report, for example, the government should still have, at a minimum, government purpose rights of that output. Marking and handling, just like under your non-disclosure agreements, it's very important that information or code libraries are marked appropriately so people understand how they can and cannot use that information. It can get challenging when there's mixed data rights, and mixed data rights are fairly common. As I mentioned, you might have a vendor who built their own software tool, such as a SaaS capability. You have the government providing information into that software, and maybe it's an AI-powered software that's building algorithms, and algorithms are being trained on your data. It can get very specific on how the different pieces of that contract are negotiated, and lots of times for good reasons. You want to protect the things that are most important to the government and its own data, and potentially preventing getting locked into a specific vendor. When we talk about commercial software, often we think of COTS, or commercial off-the-shelf software. Think of this again like a Microsoft, something that you bought that's prepackaged. It's very common to see an end user license agreement. They're pretty close to ironclad. Most companies will not negotiate their end user license agreements unless they absolutely have to. Around 2016, the federal government came out with about 4 exceptions to the standard end user license agreements used in industry, and said, if these are in your EULA, the government cannot do business with you. And it had to do with indemnification and bona fide need, anti-deficiency rules. And so now it's rare that you'll ever come across those, but of course you do want to be aware of what they are and pay attention to it. Generally speaking, industry has gotten on board, and a EULA for government-facing sales will typically reflect terms and conditions that are broadly accepted. Compliance and enforcement issues. This again comes back to marking data appropriately and making sure that information is protected and used and shared as according to the contract. For subcontracts, similar to all your terms and conditions, they're going to flow down from the prime contractor. It can get very complex. A lot of software solutions are a bundled approach, so it's not just the prime vendor's capability. If they're building a CI/CD pipeline, for example, they might have tools from other vendors baked into that overarching solution. If it's an AI capability, they may be leveraging other components or develop software that makes sense for their solution, so you're not paying for them to rebuild those capabilities. But the terms will flow down, but it does get a little bit more complex, and you do have to make sure that the subcontractor understands and you understand what rights are associated with the subcontractor capabilities. With regards to emerging trends affecting future data rights, cloud is not necessarily new anymore, but we are getting used to it. And cloud generally means that information is going to be in, whatever cloud service you're using. It's going to be all in, I don't want to say one location because the cloud isn't in one location, but within one service. And so ensuring there's appropriate firewalls. Often in government contracts, we require FedRAMPed clouds, and they have those protections to make sure where the software is being housed, where it's being built, who's building it, and who could potentially have access, because the users or the managers of the clouds will have access to that information, even if they're not necessarily working on that program. Open source software, again, not a new concept, but maybe new to the government, so to speak. Open source software, I always say it's free like a puppy. It's free to use open source software, but you typically will have to pay someone to configure and implement it. And you just want to be careful. Most open source repositories have agreements that you're going to contribute back to the community. You don't absolutely have to. It's not legally enforceable. You can always fork an open source solution and then build it in a way that's specific to a government use case. But you just want to be mindful of how you're using that open source code, and are you abiding by the community principles and practices? It's appreciated, but again, not necessarily required. And this is an evolving world here around data rights, and so always encourage you to be mindful of changes and trends. Rely on your general counsel, who typically will have someone who specializes in data rights negotiations. I hope that was helpful. If you have any questions, feel free to email me at johnmost@agileact.com and check out the additional lessons available on this page.